Good afternoon, and thank you for joining us this afternoon. Every year I find it useful to do a review of what the Court of Criminal Appeal has been doing in the previous year in the area of work health and safety. My name is Malcolm Scott, and together with my co-presenter Colin Magee, we have been practicing in this area of law for far too long. We have three cases to deal with today. The first one of those Colin appeared in, and therefore it is only right and just that he gets a chance to explain to us all about the outcome in prime marble and granite. So I'll turn it over to Colin.
Thanks, Malcolm, and again, welcome everybody to the Greenway Chambers Super Series for CPD for 2025. As Malcolm indicated, I had the unfortunate pleasure of appearing in the prime marble decisions. As you can see from the first slide, the matter concerned the interpretation of section 232 subsection 1 little a of the Work Health and Safety Act, and in particular the 2-year limitation period for the commencement of proceedings for an offence against the Act. Now, section 232 subsection 1 has some critical words in it. So it's proceedings for an offence against this Act, so it can be any offence against the Act, may be brought within the latest of the following periods to occur, and then there's a series of sections. The section that was relevant for prime marble was subsection 1 little a, which said within 2 years after the offence first comes to the notice of the regulator. So the critical thing was the principal issue to be determined was when the offence pleaded in the 2 summonses first came to the notice of the regulator. The offences related to a contravention of the primary duty provision, section 19, and in particular section 19.1, so the duty to workers owed by prime marble, and in relation to 2 workers, a Mr. Zhang and a Mr. Geng. And the offence alleged were offences under section 32, so category 2 offences. So the matter concerned silicosis. Mr. Zhang and Mr. Geng had worked for prime marble for a considerable period of time, had been exposed, it was alleged, to quantities of respirable silica dust, and it was alleged that as a result of being exposed to that dust they had acquired silicosis, and as a consequence they both died as a result of the silicosis. Importantly, one of the factors that occurred was that in 2017 safe work inspectors were undertaking essentially an educational and information gathering process. So they were going out to various operators in industry that worked essentially in the engineered stone area, so the engineered stone which have high quantities of silica in them, to essentially identify what systems these organisations had in place and to undertake essentially testing of the air in the vicinity of the workers breathing. So they put the apparatus on to measure the level of silica dust in the workers breathing zone and to measure their exposure to the silica dust. They did that in relation to 7 workers, 6 of whom were being exposed to some levels of dust, and 5 of whom to dust above the essentially the standard for exposure. Interestingly, though, that 2 workers who were the subject of these proceedings were not the subject of any testing. They were not. Their existence was not known to the safe work inspectors at the time. They didn't know they worked there. They didn't know what work they did. They didn't know whether any of the work they did exposed them to silica dust. So there was no knowledge of these 2 workers. So what then happens is in 2021, another state government entity, essentially iCare, which isn't part of Safe Work, notified Safe Work essentially of the death of those 2 workers and provided certain documents, which then essentially started the investigation by Safe Work into the circumstances of, firstly, did these 2 workers work for Prime Marble? Did they work for anybody else that could have exposed them to silica dust? And then, obviously, an investigation occurred as to, well, what were the circumstances in which they worked? What work did they perform? As part of that work, were they being exposed to silica dust? So that investigation commenced essentially in or about March of 2021. Unsurprisingly, in about 2 years later, just before the expiration of what they thought the limitation period was, because they took the view that it wasn't until they had gained this sufficient information to know those sorts of things, such as that Prime Marble had a duty or was a duty holder in relation to Mr. Zhang and Mr. Geng, what work they were performing, whether there had been a breach of that duty, whether they had been exposed to dust during that work, and obviously the causal connection, was there a failure to implement reasonably practical measures? Did failure to take those measures expose the workers to the dust and to the risk of death, serious injury or illness? So Safe Work formed the view that that notice of the offence only occurred when they had received sufficient information from iCare and commenced to undertake their investigations, and that therefore, when they commenced proceedings on the 30th of March 2023, that was within 2 years of them of the offence coming to their notice. So one of the critical things ultimately in this matter was what the words "the offence" in section 232(1)(a) of the Act meant. Did it mean the offence pleaded in the summons, and including the regulator having notice of all of the elements of the alleged section 32 offence pleaded against the respondent? Now, as most people who practice in this jurisdiction would be aware, there are 3 primary elements that are required to be proved to establish a person commits an offence pursuant to section 32 of the Act. Firstly, being the existence of a health and safety duty. Secondly, a failure to comply with that duty. And thirdly, the exposure of an individual, and this is one of the critical terms, an individual to the risk of death or serious injury or illness resulting from or caused by the failure to comply with the duty. So the regulator took the view that for there to be a contravention, each of those 3 elements of the specific section 32 offence that was pleaded must be proven. And the regulator took the view it's not sufficient for the regulator to have notice of those elements in relation to other workers that may have been at the workplace at the time they undertook that monitoring for the operation of the limitation period to occur. So it said, in essence, the offence is the combination of section 32 when read with section 19(1) and taking into account the particular workers to whom it was said the duty was owed, to whom it was said there was a failure to comply with that duty, and to whom it is alleged were exposed to the risk. Unfortunately, that was not the view taken by the CCA. So Justice Harrison, the Chief Justice at Common Law, as you can see, stated that the issue in this case is when the limitation period begins to run. That was obviously one of the few common points in the matter. The issue calls for the identification of the date when SafeWork had notice of the risk of death or serious injury or illness to which an individual, and this is the critical term, an individual has been exposed by reason of failure to comply with the relevant duty. Now, that was not the contention of SafeWork, because it's really focusing on the third element of the Section 32 offence, simply notice of the risk of death or serious injury or illness. They didn't focus on the first of the two elements, that is, when did SafeWork have notice that Prime Marble owed a duty to these two workers? Because clearly at the time in 2017 and then in 2018 when there was a follow-up improvement notice, there was no issue in the case that SafeWork had no notice that Prime Marble owed these two workers a duty under any health and safety duty, and in particular obviously the duty under Section 19.1. SafeWork in 2017 or 2018, when there was an improvement notice that was also issued following up from the monitoring, did not have any knowledge of any failure on the part of Prime Marble to comply with its duty in relation to those two workers. What the Court of Criminal Appeal focused on was that at the time SafeWork undertook that monitoring and then issued the subsequent improvement notice, it had knowledge that some of the Prime Marble workers were being exposed to a risk of death or serious injury or illness because they were being exposed to levels of silica dust at or above the relevant levels in the Australian standard. So that was essentially where the debate came to. So the CCA essentially construed the phrase within 2 years after the offence first comes to the notice of the regulator as being directed to the knowledge of an offence being committed by the respondent, rather than, as the regulator put it, the offence pleaded in the summons. And this section really deals with what is understood by the offence, and it was really, again, as you can see, that the focus is on one of the elements of that offence is the exposure of an individual to a risk of death or serious injury or illness. SafeWork's position was the use of the words an individual had to be linked back to the individuals particularised in the summons, because they are the individuals which was contended were the individuals who were exposed to the risk by the defendant's failure. And it wasn't simply any individual who had been exposed to a risk. It had to be the two individuals that were pleaded in the summons. But that was not the approach of the CCA. The CCA found that on its proper construction, the limitation period commenced to run from when the regulator had knowledge of a risk to the health and safety of the respondent's workers. So in essence, it said once you were aware that it had a duty to workers, that it was failing to comply with that duty, and that those workers were being exposed to the risk, you had notice of a Section 32 offence, and that was when time commenced, as opposed to the regulator's position, which was, well, it's not until it has information sufficient for it to have reasonable grounds for a belief that a Category 2 offence for a failure to comply with its health and safety duty had been committed, as pleaded in the summons, had been committed. So we really came down to this: an offence, an individual, versus the offence pleaded in the summons in respect to the individuals pleaded in the summons. And ultimately, the CCA rejected the regulator's position and ultimately found... No, went too far. That I consider the existence of knowledge on the part of safe work of these dust concentrations. So that was the dust concentrations that were measured in 2017 as part of the measuring, must necessarily equate to notice of exposure of prime marbles workers to the relevant risk. Now, again, the difficulty with that is the workers that were being exposed to the risk were not the two workers the subject of the charge. It then says it follows that the summons in each case was filed more than 2 years after such notice was received. His Honour's decision that notice is dependent on the knowledge of Mr. Zhang and Mr. Geng is an error of principle. The continuation of the proceedings is therefore an abusive process. And then the court dismissed the summonses. That really raises several issues going forward, both for the two regulators in New South Wales and also all of the other regulators in Australia who in the model WHS system, and also the regulator in New Zealand, because their provisions are the same. It really raises this issue, and the classic example is if an inspector goes to a work site or a workplace, identifies that there's a person conducting a business or undertaking, identifies that there is some apparent failure on their part to comply with that duty, sufficient for them to be able to issue an improvement notice. So they have reasonable belief that you are contravening or likely to contravene a provision of the Act, or to issue a prohibition notice. So in essence, to form that reasonable belief, say for example it's a contravention of section 19(1), sufficient to issue a notice, and sets out particular identified failings. You're failing to have edge protection on a building, or failing to have proper scaffolding, failing to have guarding on machinery, gives the directions, as we've all probably seen in improvement notices. These are the directions that you're required to take to comply with your duty. And then the employer, the PCBU, says, we have complied, we've done what you need to do, but no further steps are taken. If, say, 2 years and 1 day later, that same hazard and risk results in a person being exposed to a risk of death, serious injury or illness from essentially the same failure or the same nature of the failure. Say it's the same machine and there's a failure in relation to guarding on that machine. Does that mean that it's too late to commence a prosecution? Did the regulator have notice of an offence on that occasion when they issued the improvement notice? Based on the approach of the Court of Criminal Appeal in Prime Marble, that is in fact the case. The fact that two, or the worker who either suffered an injury or was exposed to the risk of death, serious injury or illness wasn't even employed or engaged as a worker by the PCBU at the relevant time the improvement notice was issued seems to be irrelevant, because knowledge of those workers is not relevant, because the offence is a Section 32 offence, if that's ultimately what you're going to plead, because of the exposure to the risk of death, serious injury, illness. The question then becomes, could you bring a Section 33 proceedings for a Section 33 offence, or proceedings for a Section 31 offence? Because the Court of Criminal Appeals focused purely on the offence provision rather than the offence provision in the context of the duty provision and in the context of the workers who are said to have been exposed to the risk arising from that. The CCA decision was the subject of an application for special leave to the High Court. The regulator contended, in essence, before the High Court, that the construction of the phrase "the offence" advanced by the CCA had the effect of discarding the requirement for identifying each of the elements of the pleaded Section 32 offence, particularly in circumstances where it was not in dispute before the primary judge or the CCA that it did not come to the notice of the regulator in 2017 or 2018 that Mr. Zhang or Mr. Geng was a worker engaged by the respondent at its workplace. So the decision of the CCA doesn't look at did the regulator have notice that a duty was owed to these two workers. Therefore, the regulator contended, well, it couldn't have had notice of the first element of a Category 2 offence in relation to the charge in the summons, because it had no notice of the first element. Similarly, the regulator contended that the approach of the CCA also failed to have regards to the requirement for the regulator to have notice of that second element. The regulator had no knowledge of any failure to take measures by the Prime Marble that was exposing Mr. Geng or Mr. Zhang to any risk at all. And it really raises the issue of what's the relevance of Section 18, the reasonably practicable test. Because if the court's not going to look at, in terms of determining when notice arises, that which is or was at a particular time reasonably able to be done in relation to ensuring health and safety, taking into account and weighing up all relevant matters. Now, at the time SafeWork undertook the hygiene testing, the air testing, and issued the improvement notice, it had no information in relation to what was reasonably practicable in relation to what could be done in relation to those two workers. And it wasn't in dispute that the summons had obviously a number of pleaded measures. It had measures in terms of starting off with measures to reduce the generation of respirable crystalline silica dust. It had measures that related to obviously reducing the exposure of workers to that dust, masks and the like. It had measures in relation to training, information, instruction, health monitoring, going off and getting tested to see, are you being exposed? Again, the CCA didn't look at any of those and didn't look at whether the regulator had notice of any of those failings at the time in 2018. So it poses a real question as to, well, when a summons is pleaded, is it simply the elements of the offence in relation to any worker, or is it the elements of the offence in relation to the workers who are pleaded? Interesting enough, one of the cases that Malcolm's going to deal with, the JBS decision, the judge in that, whilst not dealing with this issue directly, one of the points he makes in that is, well, you could have had 2 or 3 workers who were given all the training, all the instruction, all the information, but you could have had one who you hadn't. The offence is limited to that one person because that one person didn't have all the training. And that in a way is kind of the flip side of what the CCA decided in Prime Marble. It didn't look at the one person. It looked at any person exposed, and that's sufficient to kick the time off. Unfortunately, the High Court ultimately determined not to grant special leave. So these questions won't get to be determined by the High Court. But this is still a live issue because there are a number of other silicosis matters that SafeWork has commenced, and also the resources regulator can or may commence. There is one in which a plea of guilty was entered by the defendant and had been sentenced prior to Prime Marble. That defendant has now filed an application in the Court of Criminal Appeal to have both its plea and the sentence set aside, and to seek to have the summons in that matter dismissed. That's going to be an interesting one because it's a slightly different case. It's a silicosis case. But SafeWork, the respondent in that matter, defendant in that matter, had two different workplaces. SafeWork went to one of the workplaces and did the measuring, did the testing, issued notices. It wasn't aware at the time that there was another workplace and that there were workers who were doing other work. So the workplace that did test were workers doing, again, the cutting of the engineered stone, testing for that. There were also installers who were located in another part of New South Wales who essentially went to homes, went to building sites and installed the bench tops, etc., and would have to do some cutting of the bench tops to get them to fit perfectly or to put tap holes in them. And one of those workers was diagnosed with silicosis and said that was due to his exposure whilst doing that work. Now, that wasn't, again, the work that SafeWork had become aware of when it did the inspection of the other work site. It was looking at the people cutting the stone in the factory with the big saws. So that's going to be an interesting thing because that may be an opportunity to test some of these points again, and it may result in a different outcome, or it may not. And it may be on the facts of that case that we might get a different outcome. But it does raise an issue because for those who practice in the area, whether you're acting for PCBUs, you really need to ask them when you get the summons or you're told that they've currently been investigated or there's been an incident. One of the things you need to ask them is, has SafeWork visited your premises previously? What did they do? Did they issue you with notices, improvement notices, prohibition notices, and look at what was the risk that was identified, what was the contravention or the alleged contravention that was identified, what were the measures that were identified that they should take to address that was set out in the improvement notice or the prohibition notice. And because that may be a significant factor in dealing with the question of is it too late for SafeWork to commence proceedings? Or if they have commenced proceedings, is this a matter in which you ought to be advising to file a notice of motion seeking to have the matter dismissed on the basis that it's outside the limitation period? It seems to me, and I think Malcolm agrees, that this is really a matter in terms of which the regulators need to go back to government and say, we really need a definition or an amendment to the limitation period for prosecutions, so that where it says within 2 years after the offence comes to the notice of the regulator, it specifies something along the lines that the offence pleaded in the particular charge, or the elements of the offence pleaded in the particular charge, because it just seems to me that it's the potential flow-on effect of the decision of the CCA in Prime Marble can have large unintended consequences. it also really raises an issue for the regulator in terms of the objectives of the Work Health and Safety Act, because those familiar with the Act would know that the objectives of the Act are not simply to undertake prosecutions for contraventions. It's to work with industry, it's to provide information and education to industry participants, and that's often what safe work inspectors will go out and do as part of some project. They'll select an industry or a particular hazard in an industry and will go around to various operators within the industry and essentially say, we've identified, guarding issues on this machine, you need to address those. And because they're not there for the purposes of essentially investigating whether there's been a contravention and investigating a prosecution, they don't take that step, and historically haven't thought, we've issued an improvement notice, we really should, beyond improving movement notices, we should be kicking off prosecution proceedings now. And it may well be that is one of the unintended consequences, is that safe work inspectors, when they go out, will issue the improvement notice and then really need to start an investigation as to whether there should be a prosecution, rather than simply leaving it to the improvement notice or prohibition notice position. So there seems to be, in my view, a number of unintended consequences that may flow from the CCA's decision, and it may be that that's clarified by some subsequent decisions in the CCA, or it may be that the regulators need to go back to government and get some amendment to the Act. How are we going with time, Malcolm? So I'm happy to answer any questions from the floor. I don't have access.
Very important case. I'm very happy to spend some time on.
No questions. All right, well, thank you for that. I'll hand over to Malcolm, who's going to discuss the other two key CCA decisions that we've had. Thank you, Malcolm.
You better take your iPad before I knock it off. Oh. There's a little doohickey. There it is. The next case we want to talk about is Western Sydney Local Health District and Safe Work. Now, this is an interesting matter because it again is somebody trying to exercise the Court of Criminal Appeal via Section 5, capital A, capital E. What happened, as you can see there, is the Safe Work brought proceedings 19-132, risk to a female nurse of serious physical and psychological injury or illness from the behaviour of a male patient. The defendant entered a plea of guilty, but to only one particular. Now, they took the view that that particular that they've pleaded to was, if followed through, enough to eliminate the risk. And that should be the end of the argument. And sentencing should only go forward on the basis of that particular. And the argument they raised was that Section 17 management of the risk should be read to make it impermissible for the prosecutor to pursue particulars which didn't eliminate the risk but only look to diminish the risk. It became quite a complex argument. They went off to the Court of Criminal Appeal, as I say, under Section 5, capital A, capital E, of the Appeal Act, with this question from the court, Judge Strathty. Does the operation of Section 17 of the Work Health and Safety Act make it impermissible for the prosecution to pursue particulars of a charge alleging a breach of duty imposed by Section 19 of that Act, which would not eliminate the pleaded risk. In circumstances where the defendant has pleaded guilty to the charge based on the acceptance of a particular allegation, a particular alleged by the prosecution, which would have, if implemented, eliminated the particular risk. Now, the Court of Criminal Appeal wasn't terribly moved by this approach, and referred back to two other cases in recent times where this idea of taking a question to the Court of Criminal Appeal from the District Court when the trial's still ongoing, being Cobar Management, Nash and Cobar Management, and Nash and Hunter Quarries, where they raised the principle. In paragraph 19 of this judgment, they say Section 5, capital A, capital E, authorises submission of a question of law arising at or in reference to proceedings in the summary jurisdiction of the District Court to this Court for determination. Now, the words question of law are fundamental to the way that the Court of Criminal Appeal approaches these matters. And it was stated in Hunter Quarries, or in Hunter Quarries, I should say, quoting Cobar Management, that it must be a pure question of law. It should not draw the Court of Criminal Appeal into a question of fact. Moreover, they must be questions whose character as a question of law can be recognised on the face of the question and not depend upon the answer given to the question. This does not include a question which may ultimately disclose an error of law depending on an analysis of the facts, where this cannot be known without scrutiny of the facts. Now, what they determined was that the question that had been posed, which I've read to you by the District Court, is not divorced from the facts of the case. And the question involved an application of the legal principle in that section. How do you interpret Section 17 with regard to Section 19? Application of legal principles to particular facts sought to be advanced in the prosecution. So you've left with the court saying, well, we're not going to answer the question because we're not allowed to. It's outside our purview. And they say that at paragraph 25, this question does not raise a question of law. They then go on, at paragraph 27 and on, to say that even if they're wrong about that, and it is a question of law, they have a discretion. And they set out reasons why they are not going to exercise that discretion, or they do exercise their discretion to decline to answer. They then come to, in paragraph 31, this unusual situation. And it's indicative of a court that is peeved. Paragraph, where's the thing? There it is. Paragraph 31. We also consider the very substantial difficulties attend the construction for which the defendant contends. 33. The general principle is that the sentencing judge must take into account all of the circumstances of the offence, subject to the fundamental principle that no one should be punished for an offence which they are not being convicted. It's de simone. It is for the sentencing judge alone to decide the sentence to be imposed. For that purpose, the judge must find the relevant facts. In the case of a plea of guilty, any facts beyond what is necessarily involved as an element of the offence must be proved by evidence or admitted formally, as an agreed statement of facts, or informally, as occurred in the present case, by a statement of facts from the bar table which was not contradicted. Determining the facts on which the offender is to be sentenced is a commonplace occurrence and is governed by familiar principles, including those stated in the Queen and Albrecht. Difficult to see why the Work Health and Safety Act should undercut these principles. More generally, it's difficult to see why any of the provisions of the Work Health and Safety Act on which the defendant relies, including the principle in section 17 about how a duty to ensure health and safety elsewhere in this Act is to be understood, has any bearing upon the structure, substance or procedure applicable to the exercise of the discretion to impose sentence. It is a fairly straightforward and blunt assessment of section 17 and the argument that somehow or other, once you have a partial or a plea to one of the particulars, that's the end of the matter, and really the court has to turn away, or if there are matters which are particulars which will only minimise the risk, then they have to be proved. It is submitted by the defendant in this case. They had to be proved to the legal standard of beyond reasonable doubt in the sentencing process. Effectively, the Court of Criminal Appeal, as you can see, is not enamoured with that argument and put it to one side. The matter went back to the District Court, Judge Strathey. I'm not too sure what the outcome was. I haven't sought to chase it up. But one hopes that this issue was dealt with fairly quickly and the matter went on for sentencing. Now,
Can I just mention something?
Certainly.
With that? So this concept that section 17, which requires the duty holder to take steps to eliminate the risk, and it's only if they can't take measures that eliminate it that they move to measures that can minimise the risk. That concept and the particular counsel who ran the decision that the Western Sydney Local Health District has tried on a number of occasions to use that section in a range of concepts, so to suggest that if a summons pleads at an elimination measure and also pleads minimisation measures, that the prosecutor can only move to prove any of the minimisation measures if it can't prove the elimination measure, and that minimisation measures are not relevant unless the court is satisfied that there wasn't an elimination measure, and has attempted to run that point in a number of cases over a number of years in a number of different forums, and has thus far been unsuccessful in each of the different ways they've tried to put that argument. So this, I think, hopefully puts an end to that, but I'm not sure that it.
Not sure it has.
But certainly that concept that you only look at minimisation measures if you can't establish an elimination measure seems to be the point that's trying to be made, and on the basis that therefore that ultimately if the court isn't satisfied that there's an elimination measure, they can only then look at minimisation measures.
I've actually had the argument, I think, on 3 occasions in front of both Judge Russell and Judge Scotting as a prosecutor, and I've managed in each one of those matters to successfully put that argument to bed. But yes, I was a bit surprised to see it arise in the Court of Criminal Appeal. It is in fact quite a subtle argument. one of the points the Court of Criminal Appeal makes is it's not for the defendant to come along and say this is an elimination method. It may not be. That's something that will have to be determined by the court. Having a look at all the facts, the court may say, well, that may be an elimination method. They may not be an elimination method. There might be that tied to other things which will give you the ability to eliminate the risk, or a combination of matters. So that is part of the fact determination by the court, which you can go through in the sentencing process. Anyhow, I was interested to see that the matter was going on. We'll see how it comes out. Now, the last case we want to deal with is JBS. Now, this is a fact-based case, but it was determined primarily by Justice Baston. And Justice Baston has a habit of leaving us with gems in Court of Criminal Appeal matters, which then get quoted oft. I bring to your attention Nash and Silver City Mining. It goes on and on and on. This was a situation where there was a company that dealt with feedlot all across Australia, sizable company. They took a delivery of hay at one of their places. The hay bales, I tell you, weighed up to 700 kilometres, kilograms. So that's a fairly large weight going to fall down on it if it's going to fall down. They had to be moisture tested when they're being delivered to make sure that they were good for purpose. There were 2 bales that were brought in and left near a partially constructed stack. So the stack was not stable. The worker went over to test the new bales that had just come in, and unfortunately 2 bales fell off the partly constructed stack, each weighing 700 kilograms, and struck her. Did her quite a bit of damage. They were prosecuted, the company was prosecuted and convicted by Judge Scotting, and took an appeal which was interesting. But the first point that had to be determined, and was determined by this case, and it's good that it has laid down the nature of an appeal. We've all been to Court of Criminal Appeal, and we're looking at what we need to prove, either as a defendant, as the appellant being defendant, or the appellant being prosecutor, to make good our appeal. And the provision changed a few years ago as to what that meant. Capital A changed, and it took out a very clear statement of what it meant, what you had to do. What Justice Baston goes to here, and he says it about 6 times, just to make sure we all get the hint. Paragraph 23, nevertheless, like an appeal by way of rehearing, the matter is not to be dealt with de novo without establishing at the threshold there has been an error on the part of the trial judge. 24, a finding of error is a conclusory statement which does not identify the scope of the review undertaken to determine whether there is an error, and he goes through some description about that subtlety and comes up with, in paragraph 24, what is clear, however, is that the court in the present case is constrained by the need to identify error, whether of fact or law. He then takes us to Bolger, and the end of the quote of Bolger, this principle was not disputed. It follows an appeal can only succeed if the trial judge committed an error of law or applied the wrong principles to his or her fact-finding exercise. So we get to paragraph 234. He summarises it down to having had a look at all the relevant authority on the point. And he talks about the prosecutor who was the respondent in the appeal used language like the findings of the trial judge were open, which we've all done. He then goes on to say this language is usually eschewed when dealing with an appeal by way of rehearing. In the present case, it may be intended to mean that no relevant error has been identified in relation to such findings, that understanding may be accepted. It follows in relation to the appellant's challenges to fact-finding, the court should not make its own findings unless satisfied that the finding of the trial judge was attended by error. And for that purpose, at least in principle, exercise should commence by examining the findings. So he then goes in great depth to look to each one of the findings on each one of the matters raised and dealt with by Judge Scotty. He sets out the facts, the basic facts, which is one of the drivers placed two bales which had not been moisture tested nested to the partly constructed stack. Ms. Fletcher then approached the two bales to carry out moisture testing. As she did so, two bales top of the partly constructed stack fell on top of her, severely injured. So that was the basic action for which the question arose. Now the pleading went to a failure to carry out appropriate training, a failure to risk assess, and a failure to put in place a written safe work method statement. The defendant ran this argument, which I will put up now, which is in paragraphs 46 and 47. That the fulcrum of the appeal turned on two propositions. The first proposition was that prior to the accident involving Ms. Fletcher, the appellant had identified the relevant risk, namely of hay bales falling on a worker. Now, we've all been in cases like this where he said, well, the PCBU knew what the risk was and it took steps to deal with that risk, which is the second part of it. And it adopted general practices which avoided the risk materialising. The second proposition was that Ms. Fletcher herself had been specifically trained that to conduct moisture tests at the face of or close proximity to the stack was dangerous. Now, His Honour goes on, two inferences follow from these propositions. First was that there had been no breach, because there was no reasonably practicable step the appellant should have taken, but had not taken, prior to the accident. Second inference was that if further steps of the kind relied on by the prosecutor had been taken, the outcome would be no different because Ms. Fletcher already understood the risk and further training would not have resulted in her not doing moisture testing at the time and place she did and suffer injury. Now, His Honour then goes to each of the findings of Judge Scotting which undercut all that. The fact that there was no risk assessment of the particular action of which he was undertaking, which in this case is moisture testing. That there was no written direction as to what steps you should take, and particularly training to not be at that place at that time. other employees had been given training about not being close to unstructured stacks. But they were not doing the work that she was doing. They were loader drivers, forklift drivers, and persons driving vehicles in or near the stack. The judge at paragraph 90 lays down one of the statements which I think will be repeated. Failure to take reasonably practicable steps to ensure health and safety of its workers. Such a breach could take place in a number of ways. It was not necessary that each element relied on by the prosecutor. This is the section, the quote that I think that Colin was referring to. Relied on by the prosecutor need to be established. For example, if the risk clearly identified safety measures formulated and some workers only advised of the steps required to be taken, there could have been a breach of duty with respect to those workers who were not informed or properly trained in the necessary safety procedures. The trial judge accepted that Ms. Fletcher had not been properly informed or trained, nor it seemed had Mr. McKenna. That was not because the appellant was not aware of the relevant risks, now that's important, but because it had not formulated adequate safe work procedures, which in turn was a result of a failure to carry out an adequate risk assessment. It was open to the trial judge in considering this case to find that an undocumented or informal risk assessment was inadequate because it did not lead to the formulation of safe work practices which it should be accepted, had to be set down in writing if they were to be used for the training of staff as the need arose from time to time. Now, like I say, this is one of those statements by His Honour which I think will come back and be used in many other cases because it has a number of elements in it about some workers being trained but others not being trained. You're still liable. If you have an inadequate safety process and you carry out you do not carry out an adequate risk assessment, you're going to be in trouble. An undocumented or informal risk assessment is inadequate because it doesn't lead to the formulation of safe work procedures which had to be set down in writing if they're going to be used for training of staff. And he says training of staff is necessary if you're going to meet your duty. So he then looked to the role of the judge in his analysis, the judge's analysis of the facts. And the question then arose as to the likelihood of the risk occurring. Now, His Honour Judge Scotting, at paragraph 103, is reported to have found that the likelihood of the risk occurring was low. Now, 104, His Honour deals with that. The fact that the risk of death or serious injury occurring in a particular way is low does not negate the value of a risk assessment which would have identified the risk and provided the impetus to adopt safe work procedures to avoid it, nor does it cast doubt upon the contribution of the risk assessment to eliminating or minimising the pleaded risk. So, the fact that you will argue that there wasn't a high likelihood of the risk causing an injury, illness, or a serious injury or illness to a worker doesn't get you over the line. If you know that the risk is there, albeit low, you need to do a risk assessment. Now, he says in paragraph 105, with respect to causation, Ms. Fletcher's understanding of the risk which materialised can only have been a material consideration if it amounted to willful disregard of clear and precise instructions. There was no suggestion that that was the case. Now, in that sentence, he has compressed many years of judicial statements with regard to the employee who is negligent, who is inattentive, etc., and reduced it to deliberate actions. At paragraph 126, His Honour is dealing with what Justice Walton deals with in Saunders' civil build at about paragraph 268, and that's this concept. The development of safe work procedures as in fact occurred within a reasonably short time after the incident provide a sufficient factual basis for the judge's acceptance that what was done was reasonably practicable. Indeed, it is difficult to imagine any other conclusion. Ironically, the primary systemic defence raised by the appellant was that which needed to be done was entirely consistent with its own general practices. So once again, you can look to what the actions of the PCBU were after the event to overcome the risk, and that what they've done after the event is evidence of what was reasonably practicable to be able to be done prior to the event. Now, 139, the appellant's duty was to take reasonably practicable steps to eliminate or minimise a pleaded risk. Whether a particular worker faced with circumstances which materialised on the day would follow instructions or disobey them is irrelevant. If the thrust of the submission turned to the alleged adequacy of the appellant's practices or the alleged sufficiency of Ms. Fletcher's awareness of the risk, then the premises have been rejected. Just to help that matter along, that's probably a restatement of something he said earlier on. So that is the summary of that. I commend that judgment to you for careful reading, not because of its factual basis, but because of these statements of His Honour, which, as I say, I think will ring through many other cases, will be off-quoted. Are there any questions about either of the two matters? No? Everybody's happy about their understanding of the role of Section 17? And you're now ready and bid and be able to rush out to your clients and say, listen, Judge Baston said this. Don't run this argument. This isn't a good one. Okay. Well, that is the three cases that we wish to deal with today. And we'd like to thank you again for attending, either by being here or by being in the ether somewhere. And if there are no questions, then we will end the session now. Thank you.